district and this circuit, no, it remains an open question.
Because Justice Gorsuch has stated one view, and Justice Sotomayor and Justice Barrett have said this question has not been ruled on yet, so it's...
Yes, Your Honor.
And the Ninth Circuit, Fifth Circuit's looked at it, but the Ninth Circuit has adjudicated this precise question.
Not that I'm aware of. So it's for that reason that we argue that this court doesn't have the authority to issue the remedy that plaintiffs seek here.
What's your reaction to your opponent's point about there's a difference between vacator under 706 or postponement and injunction, in part because an injunction runs against individuals who are subject to immediate contempt proceedings, whereas a vacator only operates on the agency action, and any contempt is another step removed, and therefore it is a less, quote, drastic remedy.
I think that falls into this clever workaround language. Functionally, they're operating the same. So just because you have to take one more step to enforce the postponement, it's still restraining the statute.
And what about the general presumption of reviewability, given the basic value of separation of powers in our government, that when you remove effective reviewability, that perhaps by way of relief, because you can't get damages, obviously, it essentially nullifies any kind of meaningful judicial review, that the presumption generally obtains against that, and statutes should be construed narrowly to the extent they purport to remove judicial review. How does that operate here?
I think here, right, there is that presumption unless Congress is clear, and I think that Congress has been clear in the language of both 1252 F1 and, as we'll discuss later, 1254A.
Is there anything in the congressional record on this particular section that sheds light on its application to APA actions?
Not that I'm aware of, Your Honor. I have not had time to go back and look at the congressional record of 1252 F1, of 242 F1.
All right. Well, let me give Mr. Harloff the chance to, if you have one more comment, then I'd like to move on to the 1254B5A question.
Just very quickly, a few things about what Ms. Wong just said. The point about in Ken, Your Honor, is not about 1252 F1. And Ken is not construing 1252 F1. It's construing the next neighboring provision, 1252 F2. But the reason why I mention it is because it explains why a stay of removal is not an injunction. And 1252 F2 contains a different kind of bar, or just sets a very high standard for certain kinds of injunctions. And its explanation for why a stay of removal is not an injunction is equally applicable to the postponement that we're seeking here. And if you think about what a removal order is, it's an order from the Board of Immigration Appeals or an immigration judge saying this person can be deported. And the court is saying that, staying that, which is what happens when you have a deportation order that's being reviewed on a petition for review, or a removal order is being removed on reviewed on a petition for review. I think staying that is not an injunction. That's the holding of the Supreme Court in Ken. They say it's a stay, it's not an injunction. You know, what's the difference? And they say almost exactly the same argument that that I'm making here today. And it's also, as I said, the reasoning of the Fifth Circuit. Second thing, I just want to be very clear about this. The Fifth Circuit ruled on our side of this question, and I think it's 5 district courts have ruled on our side of this question. No court in this country has ruled on their side of this question. And the last thing I'll say is, if Your Honor, we're actually going to kind of try to go down the road of applying the savings clause at the end of 1252 F1, which Ms. Wong referred to, other than with respect to individuals in proceedings, there are lots of Venezuelan TPS holders who are in proceedings. Or who, it's actually, let me modify that. It's the phrase is against whom proceedings have been initiated. other than an individual alien against whom proceedings have been initiated. Our plaintiff MH, I think you were referring to them earlier, if I remember, the 3-year-old son and the 7-year-old. They have a check-in with ICE in May. There's another plaintiff, ER, so she's a 7th grade daughter, has a check-in with ICE in June. So those are people who definitely fit within the exception. There are, there's more than 84,000 NTPS, the TPS Alliance Venezuelan members. There's obviously lots and lots of others. So it would be a mess to try to limit this court's ruling in some way via that exception. And I think much more straightforward from an administrative standpoint to postpone the effective date of the rule and preserve the rights just like every other normal APA case, Your Honor.
Well, that's sort of, I'm not sure which way that cuts, because if there are folks who are could get relief under the savings clause, I guess the comeback to that is that, well, then they should seek individualized release and not a wholesale invalidation of the Secretary of Nome's vacator.
Well, so to be clear, everybody loses their employment authorization. And there's many reasons why I think this provision doesn't apply that we didn't get into. One of the many is that once CPS expires, you lose your employment authorization. That applies to everyone.
That wouldn't be a proceeding brought under this part, such part.
I think, other than with respect to an individual against whom proceedings have been initiated, refers to removal proceedings. That's my understanding of what that term means. And then there's obviously a number of massive. So I would argue the harm that we're talking about, the $3.5 billion for the April crowd and about $8 billion for everyone, that's triggered totally aside from whether or not people are put into removal proceedings. But the reason I raise this is to say that it doesn't make any sense that a provision like this, with an exception clause like that, would apply to this sort of programmatic policy where you're going to strip all these people of their employment authorization well in advance. But even if you reject our view, you'd have to split with the Fifth Circuit and all these district courts, and you'd have to explain why this is consistent with APA doctrine, which they still haven't done. All they've said is they think all the APA doctrine is wrong. But even if you went that road, we wouldn't be done. We would then, we'd come back here and say, there's thousands of people who, even under their interpretation, are entitled to relief and could be getting relief in this action, in this case. It doesn't say that you have to bring it in removal proceedings. It just says that you can't grant an injunction other than with respect to an individual against whom proceedings have been initiated. So, it's just all to say, like, they point to this as though it's a solution to the problem, but it just opens its own massive can of worms.
Well, I'm not sure they're saying a solution. They're saying it informs the interpretation of the rest of the statute. You've got a savings clause that's been delimited, and therefore that would, I guess, argue for a broader interpretation of the front end of the statute.
I see. So then my answer to that would be the point I just made a minute ago, which is that there's a huge amount of harm caused by the termination, which cannot be addressed by waiting to raise challenges in removal proceedings. So it doesn't argue for a narrow interpretation on that basis. And the other thing I would say, Your Honor, is, as I understand it, their position is that the illegality of the TPS termination and vacatur cannot be raised in removal proceedings. That was their position last time anyway in Ramos, that we couldn't litigate these questions we're litigating now. Of course, the individual in removal proceedings couldn't compel the production of the administrative record, what we started the hearing with. So for both of those reasons, I would argue that the existence of the savings clause cannot be sufficient to resolve the problems that would be created by stripping.
In other words, there's no other forum to litigate this. It would preclude entirely judicial review, hence the rule of construction about narrow construction of such
Yes, Your Honor.
prohibitions.
Yes.
All right, we got to move on. Thank you to the other jurisdictional question, and whether that means judicial review, which is barred with respect to, quote, any determination with respect to the designation or termination or existence or extension of a designation of a foreign state. We did look at this question, and so did the Ninth Circuit panel in the now vacated Ramos decision in the Ninth Circuit. But the vacated decision, even the majority there, reached conclusion that the sweep of 1254B5 is limited, that determination, which is a key term here, pertains to review of the underlying considerations and reasoning employed by the Secretary in reaching her country-specific TPS determinations, determining whether or not conditions are so adverse that it's dangerous to send people back. Those are the kinds of things that are generally not reviewable, but that sort of procedural or collateral matters can be, and even under that framework, which is not binding here because that decision was vacated, but it's an indication of at least how 3 judges look at it. You look at such factors under McNeary, as I understand it, as cited by the vacated Ramos decision. Is the review based on the merits of the individual situation, or is it a broad challenge? Is the administrative record for a single decision, does that have any relevance? Is that needed in the determination? And is the examination peculiarly within the agency's special expertise or integral part of its institutional competence? I mean, those are some factors that you looked at to determine whether it's that a determination or whether it's really collateral to that. And so here, if we look at the whole question of the vacator, not necessarily the termination, but just the vacator of the 2023 extension, that question seems to be a matter of statutory interpretation by each side, and whether or not the statutory framework of the TPS statute allows and has implicit authority or not. That doesn't sound like the kind of determination of country conditions that the Ramos case was referring to. And if you look to the reasons justifying the vacator, again, they were not so much based on analysis of country conditions, but really sort of whether what was done by Secretary Mayorkas before was so novel and perhaps inconsistent with the TPS statute, as was mentioned, and maybe, ultra virus or whatever, but again, didn't seem to be based on country conditions or anything akin to that. And so the record that you would look to, the agency expertise about evaluating country conditions and the safety of the return of folks doesn't seem to be at play here. So it seems to me, although this case is a slightly different question that's being raised than in Ramos, the framework, if we were to accept Ramos, at least the majority opinion, would suggest that 1254B5A would not bar, because this is not a, quote, determination within the meaning of that statute. So I'm going to let the government respond first. That'll give you a chance to respond, Mr. Arnold.
Your Honor, I think we need to go back to the text of the jurisdictional bar at 1254A-B5A. And the language is any determination of the Attorney General with respect to a designation or termination or extension. And that any has a broadening effect of the word determination. Since the last time we were here arguing this statute, the Supreme Court has weighed in again in the Patel case, Patel v. Garland, and has stated that any does have a broadening effect to the next word, to that determination. And so here, where the statute provides inherent authority to revisit decisions, the decision by Secretary Mayorkas had not even gone into effect. The Secretary Noem came and was able to relook at that decision and determine that it didn't meet the statutory needs. She noted, I find my language, she did note that she was relooking at it not only to untangle confusion and provide an opportunity for informed determinations, not only to untangle confusion, but to provide herself, she gave herself the space to make an informed determination regarding the TPS designation, and then clear guidance from the president that she was to look, the guidance being that she was to look at these designations and determine if they met the statutory requirements of the TPS statute. So I'm mixing arguments here, but the inherent authority to issue the vacatur is then swept up once she makes that decision to vacate the extension. That decision is then swept up under 1254A B5A as any determination, as one of the determinations.
Well, but in your
under
reading,
any.
if the bar of 1254 is so broad, we wouldn't even reach the question whether she had authority or not. We wouldn't even reach the question whether what she did was reasonable. There would just be no review. That whatever she did, no review, period.
I think that the Ninth Circuit and Ramos and yourself indicated that you could look at legal questions surrounding the interpretation of the statute. So,
Okay, so you could have judicial reviews to in construing the statute, for instance, and determining whether or not there was implicit authority or not?
yes, Your Honor.
Okay.
But then once you look to determine that that the statute does provide that inherent authority, implicit authority, from there, the decision itself and the evidence and decision making by the secretary, then you look at the language of the statute and note that, and it is a determination relating to, in this case, an extension.
Okay, so as I understand it, you would concede that looking at the statutory question, the first question of whether there was implicit authority under the statute, which is a matter of statutory interpretation, is within the realm of what this court can do. But if then I were to find that there was authority to do so, the way she exercised it, the reasons why she exercised it, that's where the bar on judicial review